Until October 2015, Dr. Hilaire served as Saint Lucia's British High Commissioner. This same year, he purchased the vehicle central to this controversy. The vehicle was detained by Customs and the matter was investigated from 2017 to 2020 by the Customs Department. In October 2020, then Controller of Customs Peter Shiko filed 3 cases with the Department of Public Prosecutions against then Deputy Leader of the Opposition Saint Lucia Labour Party, Dr. Hilaire. Hilaire responded by filing a lawsuit against then Controller of Customs, now endorsed United Workers' Party candidate for Castries East, Peter Shiko, in February 2021. After mediation held in December 2021, Shiko claimed that Hilaire withdrew his lawsuit in exchange for the newly appointed controller, Sherman Emmanuel, to withdraw the cases against Hilaire. This decision by the Customs Comptroller prompted Allen Chastanet to bring the matter before the courts. The case was first dismissed by the High Court in August 2023 and again by the Eastern Caribbean Court of Appeal in April 2024. Garth Patterson, who represented Chastanet in his final appeal before the Caribbean Court of Justice, CCJ, once again argued against Emmanuel's decision to withdraw in the hearing of appeal on Wednesday.
That proviso part does make an allowance, doesn't it? That allowance is that any other authority other than the DPP, the provision allows for discontinuance of prosecution if the judicial leave is granted to do that. Is that correct?
Our position is that that provision simply preserves that power if that power has been conferred.
Anthony Astafan, who represented the controller Sherman Emmanuel and Paul Noel, the respondents in the case, argued that Chastanet, as the claimant, had not sufficiently proved to the court that it was unlawful for the case to be withdrawn by the controller.
In this case, very serious allegations have made with very little, if anything, to support the allegations made. The Privy Council said this: the more serious the allegation or the more serious the consequences if the allegation is proved, the stronger must be the evidence before court will find the allegation proved on the balance of probabilities. Thus, the flexibility of the standard lies not in any adjustment to the degree of probability required for an allegation to be proved, such that a more serious allegation has to be proved to a higher degree of probability, but in the strength and quality of the evidence that will be in practice be required for an allegation to be proved on the balance of probabilities. In fact, we understand this decision to be saying if there's the context of a prosecutorial discretion with very serious allegations being made, evidence has to be clear and strong.
The president of the CCJ, the Honorable Justice Winston Anderson, raised the question of whether or not the Controller of Customs is the correct person to challenge in this case.
Where I was going with what I raised was the fact that there is a distinction between the DPP and the non-DPP prosecutor. And that distinction, I think, came up in the questions asked by my brother, Justice Osuji. The point is that the non-DPP prosecutor has to have leave of the court to discontinue, withdraw criminal prosecutions. And you would have seen, of course, that occupied much of our interactions with Mr. Patterson. I wanted to get your view on that thesis of the case, which was provoked by the questions by my brother. What do you think of that hypothesis, that once the court or magistrate has given leave, the effective decision is that of the court, and therefore a challenge to the process ought to occur in relation to the decision by the court?
For Choice News Now, I am Cianna Dalsan.